We have talked about copyrights and trademarks, which are legal protections that exist in Kenya. So today I want us to cover the next legal protections. This is day 55 of building an AI startup in 120 days. If you're building a new tech innovation, should you file for a patent or a utility model? Many startups don't actually know the difference, and this means making the wrong choice could waste years and a lot of money. In Kenya, both patents and utility models offer legal protection, and this is under the Industrial Properties Act of 2001, but they serve different purposes. So let's break down the key differences between each one of them and which one is better for your startup. Number one, what is a patent? So this protects new groundbreaking inventions or technological processes, and it provides a protection for 20 years. That is, if you renew it. And for the requirements for this are a little bit strict. The invention must be new, non-obvious, and industrially applicable. And this is under the Section 21 of the Industrial Properties Act. The downsides to filing for patents is one, they are expensive and time consuming. That means it can take years for them to get approved. And for a startup that's trying to move fast, maybe may not be the exact thing you need, unless you're coming up with something that's very new, very inventive, and where speed to market is not an advantage. If you invent, let's say, something like an AI-powered energy saving system that has never existed before, a patent gives you the exclusive rights to use it or license it for 20 years. So this provides comprehensive protection. If you feel like ain't nobody got time for that, then the next protection might be what works for you, and this is a utility model. So this protects small but useful innovations that improve existing technologies, and this usually covers a period of 10 years, which is and it's cheaper and faster than a patent. So the requirements for this are a little less strict. Yes, it must be new and useful, but the invention can be minor. So it can be an invention within a process. Uh, and then it must also be industrially applicable, even if it does. So that means it doesn't have to meet the requirements of a patent. So the downside is that it does not give a strong monopoly, like the same way a patent would do. And an example of this is, let's say you're working on an AI model that processes data like 30% faster. And it's based on known technology. Let's say you're using OpenAI or something. So you might qualify for a utility model instead of a patent. If your innovation is a major breakthrough, patent is the way to go. But if it's a small valuable improvement, then you go for a utility model. For tech startups, filing a utility model first can be a smart move because it gives you legal protection as you refine your ideas.